I have seen that a lot of people feel as though they know their family members until somebody passes. And then you find out that you really didn't know that person, because greed and the desire for money can really change people.
Wow, greed and desire for money can really change people. Tell me more.
Someone that was kind to you this whole time, all of a sudden, because there's money on the line and they want maybe more than what they were supposed to get, you see a different side of them. So I always tell people, when you set things up yourself, you are avoiding other people having to figure out who should get what. And that'll also help their relationships in the long run. When you have a will, you are telling the probate courts who should get your stuff.
Let's not assume that the children now disagrees on what should happen to the assets. So what happens in that case?
That's why having a will is important. And that's why telling the world who should get your stuff is important. Because if you have a good will with the right language in it, you have something called a no contest clause.
A no contest clause?
No contest clause, which means if someone tries to contest, they're not going to get whatever it is that you did not want them to get.
You are welcome to the voyage, the trials, the transitions, and the triumph of people all over the world. We are afraid to talk about death. We don't plan for it. We don't even like to think that we will die one day. But whether we like it or not, death is inevitable. And today's conversation is one of the conversations that people don't like to have, because of several reasons. I believe anyone that is alive needs to watch this session today, because it is important and it is vital. So let's dive straight into our conversation today. My guest today is an estate attorney, and she's going to tell us all that we need to know. One thing that is important is this. This session today is born out of a personal pain and also out of a personal experience. I was aware of someone that died without a will, without a trust, and she has a property, and she lost more than $70,000. Let me say that again. She lost more than $70,000 because she did not have a will or a trust on what to do with her property. So today will be a session for you on how to avoid such kind of a loss. Whether you have a property or not, as long as you have a life, it is important for you to watch this conversation, not just the beginning, but through to the end. So let's dive straight in. You are welcome to the seat of the Voyage, Sephora.
Hi, DJ.
Can we please, meet you? Let's get to know you. I know you are a lawyer by profession. Yeah. So how did you get into, estate planning and stuff like that?
Yeah, well, estate planning is not something that a lot of people know about. Even in law school, it's not something that was pushed on us at all. The law that most people know is criminal law, family law, personal injury, immigration. Most people don't know about estate planning, whether it's from the legal side or just from the regular day-to-day life.
Okay.
So when I was transitioning from criminal defense into trying to find a new field to work into, estate planning came my way. And I had to learn a lot on the spot myself, because there's so much that even I didn't know when I first started. But working in estate planning now, there's so much that people just don't know. And to your point, it's the things that you don't know that can really get you into trouble, because when you find out later on, you may not be able to always change or to update things, especially if you've already passed. So I love what I do with estate planning, and I see it as an opportunity to build legacies for people. The work that we're doing in estate planning, it goes for generations to come, not just the people that I see today.
Okay.
But I'm able to help families at every stage of their lives, grandparents, parents, their children. So yeah, I get to meet some great people and help them along the way too.
That's awesome.
Yeah.
Now, I'm embarrassed and ashamed to admit that I do not have a will, neither do I have a trust myself.
Yeah.
And I know there are many people out there too that do not have a will or a trust, because I think in good state of health And at times I said, I don't have anything. Why should I have a will or a trust? And I'm not dying tomorrow.
Yeah.
So I guess maybe there is an ignorance in that statement, which a lot of people are willing to admit. So let's face it headlong. If I die today, walk me slowly through what will happen to me, well, to my children, to my wife, to whatever asset that I have, without a will or without a trust.
So without a will, without a trust, no one knows who's supposed to get your stuff. So everything is frozen.
Frozen?
Frozen.
Really?
Your bank accounts, for example, if you did not tell them who's supposed to get it, they don't know who to give that money to. Your property, same thing. You didn't tell the government who's supposed to get it, they're not sure who to get it to. If you have minor children, the government doesn't know who you want to take care of your children. So there's limbo there. Not just for what you want to give to your children, but who is supposed to be their guardian, who's supposed to take care of them once you pass away. So the creation of a will, the creation of a trust is a way for you to tell the world who's supposed to get your stuff when you actually pass. That way there's no limbo as to who was supposed to have it. And when you don't tell the world who's supposed to get your stuff, the government decides who's supposed to get your stuff.
So you said, if I die without a will or without a trust, legally speaking, everything will freeze. Everything will be frozen.
It's frozen until we decide who's supposed to get it.
And government make the decision for me.
If you don't have anything set up, yes.
All of my hard-earned labor, everything will be decided by who I don't even know.
Right. People who don't know you, they don't know your family situation. They don't know the people that they might pick, right? Say they pick a family member, for example. This may not be the family member that's best with money. This may not be the family member that you think should take care of your children, raise your children. So unless you have decided who's supposed to get it, you're leaving it up to complete strangers to decide.
This is quite shocking to me.
Yeah.
So, walk me through, what does a probate look like in real life, and what is a probate?
So probate is the way for the government to see what you had and who's supposed to get it. So if you have a will, for example, it's still going to go through the probate courts. Probate is like criminal court, like family law court. When you pass away, the probate court is the one that decides this is what DJ had, this is who should get it. And if you have a will, they follow what the will says. But if you don't have a will, the state that you're in is deciding who gets your stuff. And the probate process takes some time as well.
Okay.
In a lot of counties in the United States, you have to hire an attorney to start the probate process. In other words, when you pass, your children don't just bring the will to the courts and say that they want to start probate. Normally, they have to hire an attorney. The attorney is the one that files the will with the courts. And then you have multiple hearings. It's a long process. It usually takes either a few months up to years. I've seen probate go on for 8 years for some people who don't have things set up properly.
So, at that point, I imagine the grief, the panicking, the emotional turmoil that the family will be going through. That at times it may not even be the pain of the person that died, but rather what to do with the asset or even the debt that is left behind.
Right.
Have you experienced things like that with any of your clients in real life world?
Absolutely, because you're mourning the loss of the person that you lost. But at the same time, you're trying to pick up all the pieces. Most people don't know where their loved ones were banking. They don't know account numbers. They don't know who to call. They don't know where the assets were. Even the things inside of the house, they don't know who's supposed to get it. So in addition to mourning the loss of the person that you love, that you consider to be family, you're also trying to figure out how to shut everything off that they had. Electricity, utilities, everything now has to be shut off. But if you don't have a proper plan in place, now you're having to pick up all of the pieces while at the same time mourning.
So, talking about property in particular, during probate, who owns the house during probate? Who legally controls it? And can the family sell the house during probate? And maybe can they also refinance it or cash out, take money from the equity in the house during probate?
The house stays put during probate. No one is selling the house. No one is refinancing the house because the court is going through their process of trying to figure out who should get it. So if it takes 3 years, that house is sitting there for 3 years.
Wow.
Yeah.
That seems unfair. Or is it ignorance? Or is it ignorance?
Well, not all probates take 3 years,
Okay.
right? It may take a few months, especially if you were a married couple, for example. But the court wants to make sure that the right people get that asset. And if it takes a long time to do that, I mean, if we're talking about hundreds of thousands of dollars, they want to take their time to figure out who should get it. But for the family members who are saying, I need this property to be sold, I need the money quickly,
Yeah.
you're on hold because you have to wait for the court to finish their process, and they run on their own time. They don't care that anybody else has an emergency. You're going through the court's process.
Even if there is a will.
Yes, because wills still have to go through probate. People don't realize that.
Really, will still have to go through probate. It is not that, oh, now I have a will, then that is final.
No, when you have a will, you are telling the probate courts who should get your stuff. So probate will be quicker, but you're still telling them who should get it. And once you go through the probate process, then they are actually giving out those assets to your people that you wanted to have it.
Interesting. So let's assume that the person that died, they still have a mortgage loan on the property. Then what happens to the monthly payment since the person that pays it is already dead?
Right.
So can the bank foreclose the house during that period, or what actually happens?
Yes, the bank still wants to get paid.
That is true.
So hopefully there's somebody there that's paying the bank. But if the bank is not getting paid, they will absolutely foreclose. So
Really?
Yes. So having money set aside for what ifs, if you pass away, having someone to assume the mortgage when you pass away, say you're giving the property to somebody else, they need to continue to pay the bank. Otherwise, the bank will take that money back.
But no family member will want to take that risk, not knowing what will happen
Right.
to the property at the end of the day.
Exactly.
They continue to pay the mortgage, and what if at the probate court they decide, in a way that will not favor them?
I see what you're saying. So even with probate court, if your son knows, for example, that he's going to inherit that property, he can continue to pay the mortgage. The house is going to go to him.
Okay.
No one's going to fight him for it.
Okay.
Unless you have a situation where people are fighting for your stuff. That's a completely different conversation.
Interesting.
Yeah.
So that leads me to my next question. Let's now assume that the children now disagrees on what should happen to the assets. So what happens in that case?
That's why having a will is important. And that's why telling the world who should get your stuff is important. Because if you have a good will with the right language in it, you have something called a no contest clause.
A no contest clause?
No contest clause, which means if someone tries to contest, they're not going to get whatever it is that you did not want them to get.
Okay.
So if you wanted the property to only go to child A and child B wants to contest, you already have language in the will that says this only goes to child A and no one else.
Okay. Interesting. So if still on this issue where children disagree with the will, so let's say if siblings inherit a house without clear instruction and one wants to sell it while another wants to keep it, so how does that usually play out?
Yes. It gets
It's messy.
very messy. And that's why you see situations where you have one sibling that owns 50%, but they want to sell the other 50%. The other sibling wants to sell the other 50% to someone else. And it gets very complicated even when it comes to the title of the property. Okay. Now we don't know who owns it. Or you own half of a room, the other person owns the other half of the room. So having things laid out ahead of time is extremely important. So if someone wants to sell, maybe you force them to have to sell to their other sibling first as opposed to a third party. That way the property can stay in the family.
So let's assume that one of the children is living in the house. Yeah. Does that give that person an advantage?
Absolutely not. Just because they let you live in the house doesn't mean you own the house. But some people may think otherwise. They may say, I've been living with mom and dad for 15 years.
Yeah.
I should own the home. That doesn't mean you own the home.
Really?
No, it depends on what they wanted. It depends on what the person who passed wanted.
So let's look at a case where if someone dies, they are not married, they have no children, and there is no obvious next of kin.
Yeah.
So what happened to their property? Possibly they have even almost paid their mortgage.
Right.
So what happens to their property? They are not married, no children, no clear next of kin. So what happens to the property in that case?
The court will try to find somebody, whether it's sibling, niece, nephew, second cousin, they will try to find someone. But if, to your point, if we can't find anybody, the court will take it. The government will take your money. They'll take your asset because there's no one to give it to.
So let's assume that this is scary. Let's assume that the siblings are in another country. So what happens in that case?
If they can come to the U.S., great. If they can't come to the U.S. to say this asset should be mine, there's no way to reach them, the state will say, well, there was no one to get it, so it should be mine.
Wow. Now, under what circumstances does the property ends up in the hands of the state, that the state takes ownership of the property?
It's really if there's no one else to get it.
Okay.
And if no one wants it either.
Earlier on I talked about a personal experience that I'm aware of where someone lost almost 70,000 because the house went into probate. In your experience, when families are forced to sell during probate, how often do you see that they lose equity because of delays or legal fees or because emotional conflicts? How do people actually gain when property or assets go into probate and they are forced to sell?
I don't see the gain in that. And I think that there are other ways to give your property over to your family while avoiding all of the things that you just mentioned, because it does cause a lot of turmoil. It causes a lot of stress. You could end up losing a lot of the equity that you mentioned earlier just because of the delay in the process that comes with probate. And so what I would recommend to people is to try to avoid the probate process as much as possible for the reasons that you mentioned.
So how does tax comes into play when a property goes into probate or a property is will? Can you share with us on generally how does tax comes into play in terms of the legal tax that they have to pay?
Yeah. So when it comes to leaving a property to another person, depending on the state that you're in, you'll have either state tax, which Tennessee doesn't have, neither does Texas, luckily, but you also have federal taxes. Okay. So you always want to keep in mind that there are federal taxes to consider. Now, when it comes to things like property taxes, the person who passed, depending on how old they were, they may have had some property exemptions. When you assume that property, that doesn't mean that you're assuming their exemptions. Say they had over 65 exemptions, for example, veterans exemptions. When you inherit that property in your name, you're not keeping their exemptions. When you sell the property, depending on how the property was given to you, you may end up having to pay capital gains tax, which is a gain in the value of the home from the time they purchased it to the time that you are selling it, again, depending on how they gave you that property.
So what are the ways in which the property can be transferred?
Perfect. So things like a will is a great way to avoid capital gains tax for the beneficiary. Things like a trust, or even depending on the state that you're in, maybe there's a special kind of deed that the person that owns the property now can create and file with the county. That way when they pass away, they're telling the county who should get the property. What to avoid is adding your children onto the title of your home as a co-owner.
Hey, sorry for interrupting you there.
Yeah.
You said what to avoid is to add your children on the title deed as the co-owner.
Right.
What is the danger in doing that?
People assume that when you add your children onto the title, that means that they don't have to go through probate and you're making it easier for them, which is true. They won't have to go through probate because you own that property alongside them at the time of your passing. But because you added them onto the title as a co-owner, When it comes to paying capital gains tax when they're selling the property in the future, it'll be considered as though your name was on the title from the very beginning.
Oh, I see.
The new beneficiary's name on the title from the very beginning. So if you gave them that same property from a will, if you gave them that same property via a trust, you get what we call a step up in basis. In other words, they're not having to worry about capital gains tax. But simply because their name was added onto the title as a co-owner, now they will have to pay that capital gains tax when they sell the home in the future after you've already passed.
Which can be like up to how much?
It depends. It depends on the gain in the value. And most properties, they only go up in value. They don't go down, right? So if you purchased a home in 1980 for $150,000 and your family's going to sell the home in 2050, now we're looking at a gain in the value of the home from 1980 to 2050. That's a big gain.
And what is the percentage usually?
It could be 20%. It could be less. It depends on...
20% of the proceeds of the sale.
Right.
That's a lot of money.
Right. And it just depends on the laws at the time of when you're selling the property.
So what is the better approach instead of adding one's children to the title deed? What is the better approach then?
A will. However, the will go through probate.
Okay.
A trust is a great way to do it because trusts, if made correctly, they will avoid the probate process altogether. In fact, that's why people like trusts, because they want to avoid that process. Or even something as simple as the deed that I mentioned, the transfer on death deed, where you're listing a beneficiary for the property on the deed itself, as opposed to listing them as a co-owner.
Interesting. So this is an interesting one that earlier on we talked about people can either leave assets or liabilities.
Right.
From your work experience, how often do families discover their loved ones leaved debt behind, and what happens at that point in time?
Well, I won't say that it's too often.
Okay.
Because I really try to help my clients prepare ahead of time. That way we don't have to deal with that conversation later on.
Okay.
And I have to tell their family, actually, he left you a lot of debt before he passed. But in cases where debt is left, a lot of times the money to pay for the debt will come from the rest of that person's estate. In other words, maybe the property will need to be sold, and instead of their family getting the full percentage that they would have gotten before, they're getting less because they have to pay off the debt first.
People make assumptions when it comes to what happens to their assets when they die, or even when they will die, because a lot of people are not prepared for it.
Right.
And I guess as Africans, we don't like to talk about dying, right? What emotional damage have you seen when siblings, families begins to fight and contest over assets and properties when their loved one dies?
It's really sad, DJ, because I have seen that a lot of people feel as though they know their family members until somebody passes.
Oh, really?
And then you find out that you really didn't know that person. Because greed and the desire for money can really change people.
Wow. Greed and desire for money can really change people.
It can change people.
Tell me more.
Someone that was kind to you this whole time, all of a sudden, because there's money on the line and they want maybe more than what they were supposed to get, you see a different side of them. So I always tell people, when you set things up yourself, you are avoiding other people having to figure out who should get what. And that'll also help their relationships in the long run. We're not going to have conversations of, oh, mom wanted me to have the house, but she said it at some point back in 1970. And there's not another person saying, well, I'm the oldest, so I should have a larger percentage.
Yeah.
Whereas some might say, well, we should have things equally because, there's equal amount of kids and everything was equal with our parents. So having everything set up ensures that you're even helping the relationships of your children in the future. They're not having to fight to think who should get what.
I see. What is one single biggest mistake that homeowners make before they die?
I'd say thinking that the property will automatically go to spouse or anyone else.
Wow. That thinking that their property will automatically be transferred to their spouse or children is the biggest mistake that homeowners make
Right.
without a will or a trust.
Exactly. Without a plan.
Huh. Interesting. So if there is someone out there now that has a property but they don't have a will, they don't have a trust, what would be your message to such a person?
I would tell them to sit down with an estate planning attorney. And the reason why I say that is because going back to earlier, I said when you don't tell the government who's supposed to get your stuff, they decide. So, for example, in Texas, when someone passes away who did not have an estate plan and they had a blended family, Texas has decided that the person who passed, their share of that property should be divided amongst all of the children.
Okay.
Not necessarily spouse. In states like Tennessee, same situation where you pass away, you haven't left an estate plan. The court may think that surviving spouse could only get a certain percentage, and the rest be divided amongst the children. Depending on the relationships that you have with the children, that can cause a lot of strain, especially if it's a blended family. So the assumption that that property will automatically go to spouse 100% when you pass away without having to do anything, without having to go to court, without having to file anything with anyone, it's not true.
Wow. So if anyone has a property and they don't have a will, they don't have a trust, they are more or less working for someone else to reap the fruit of their labor.
Maybe, depending on, where they live, depending on their situation, right? If
Okay.
it's just the two of them, they don't have any children, then yeah, it'll go to the surviving spouse. But things can get very complicated very quickly, depending on your family situation.
Interesting. So, well, in the next video or the next session, we'll dive deep into will and trust, which one is better and how they can be set up. But, just trying to focus on people that has property, and because it pains me that you have almost 250,000 equity on a property and you don't have a will, you don't have a trust. You assume that, maybe you will not even die because nobody plans to die.
Right.
And then you died, but your asset is now being decided by someone that you don't even know.
Right.
So the wisdom is to sit down with a professional like you, with an expert like you, to be counseled and to take the so what will be the first step for someone to take? They have a property but they don't have a will, they don't have an asset.
Yeah, the first step is to definitely sit down with an estate planning attorney if you can. If you can't, look up a financial power of attorney.
Okay.
That's a document that you can find online if you really can't sit down with an attorney. But with that document, you can write out who should be in charge of your estate, who should be in charge of your assets, in charge of the property if something happens to you, but you're still alive. Maybe you're incapacitated. That way, if something happens, you still have someone that can make those decisions on your behalf if you can't make them for yourself.
And is that binding? Is that legally accepted?
100%. If you have that financial power of attorney, then if I was your agent, for example, I'm the person that you chose, I would be able to create an estate plan for you.
Oh, really?
Yes, I'd be able to help with any deeds on your property for you while you're still alive.
Why you as the person is but what about when the person dies? What happens?
When the person dies, that's where we're going to wills and trusts. If you don't have it before, then, things get complicated. But if you're still alive, the first thing I recommend, get that financial power of attorney, sit down with an attorney if you can.
But that financial power of attorney has no effect as soon as the person dies.
Right.
Wow, that's not good.
Right. So there are a lot of different documents that come into creating an estate plan.
I'd say. Well, on that note, we will wrap up this session that when you have a property, you have an asset. It is important to secure your asset either with a will or with a trust. Until the next time, Let's continue the voyage and let's keep creating beautiful memories.